comes to matters before pending here, you take responsibility. You can't run away from it, Mr. Chair. We are indicted. Council were never spared. The petitioner was calling us a battle of lawyers here to delay and waste time and do all manner of things. We have spent our lives to come to the cause of justice, for which you all seek. For God's sake, there are no lives that are unlimited, except the life as enshrined in the Constitution, Article 27, I believe. But here, this committee is telling the petitioner, we have your back. Go out there, do what you want to do, say what you want to do, you come before us, it is business as usual. It is not going to be business as usual, if that is the intent of this committee. We are here to act for honorable men and women, and they should be so perceived until proven otherwise. None from our end has expressed in any way, manner or shape, anything personal against any of the committee members, because we respect who you are. We respect the institution and the hallowed seats you take. Honorable Chair, Kakamega is part of a bigger country called Kenya. And the Kenyans have become the most versatile people in terms of information. Some of my clients have received the same clips from their relatives in diaspora, say us questioning who they have become simply because a petitioner is allowed.
I'm not stopping you, but just moving from different direction. And we share the remorsefulness in the way you articulated the issue concerning the image of yourselves, the image of your clan that has been put in public. However, I wish that if we do not now restrict ourselves within the timelines, and for the reasons that we've been given as a committee what is awaiting, please kindly address within the next 2 minutes, and we shall make a communication in that council.
I wish I wish we started with such outreach as communication from the chair. It would be shared if that were the way to begin. I want to imagine what Honorable Pius, Honorable Mori would be doing if this were him, going through the kind of agony. You are mourning your colleague. Our clients are mourning their persona. They are mourning who they have been. Their other person was killed yesterday. As council, we want to protest and say we do not allow, not even the courts, do disparage us for who we are when we are pursuing justice. It cannot be that a citizen appearing before this committee can be allowed to cast aspersions on us. We don't want to question whether he's ever been to the basic AECD class. We respect that. But for him to go into the depth of who we are, this is us. This is what we do, and we believe we do it well. Let me say that we'll want this to go on record, and we would request that this committee expresses itself in manners that it can master in terms of seizing the proceedings, taking charge of the proceedings, directing our conduct, and ensuring that the men and the women who step here go out as innocent as they came in until pronounced otherwise by a competent body. With those, I reserve my anger and request and perhaps pray that the petitioner be man enough to say what he said again, and we'll certainly face each other in a different forum. With those remarks, I submit.
I was admitted to the bar on 2nd of October 2006.
Thank you, Council Chifoka. Please, we also donate you 2 minutes.
Most of that. I may appear fairly young, but I'm old enough and well experienced to the point that judge of the Court of Appeal. Yesterday, this man appeared in with customs of international repute and indicated that my purpose for appearing before you was to begin the hearing of this particular petition. In addition, since you, the committee, accorded us time to address you on the issues we felt were of import to your mandate, he in effect implied that you acquiesced and were active participants in wasted time. Time is a precious resource. You will agree with me, one of the integrity issues is punctuality, time consciousness, and discipline, social discipline. And if you can fail on those fronts, then it will be very difficult for you to be appointed in any public office. This man here, the petitioner, who was already accused of clients, has now degenerated from the allegations against our clients to now the attack on counsel. The right to fair trial involves sufficient and substantial protection to the participants in that trial. This includes the protection and sufficient respect and dignity being accorded to not just the litigants before you, but yourselves as a judicial entity, and the counsel who are assisting you receive information and facts and evidence that you're supposed to sift through. So by this man making those allegations in public media, he has discredited, lowered the dignity of all of us. I do not know if you feel the same. I do not know whether you care about it. I do care about myself and my name. I wish to make an application that this petitioner is severely admonished, made to retract what he did to the media over both counsel and their clients in a similar fashion as he did yesterday. We have seen the clips all over on social media. I do not know if you've seen them, and expected that if the committee had seen those clips, and on the basis of my understanding, and possibly the basis of Mr. Waluya's understanding, we should have begun by first calling him to clarify and justify why he had to make such remarks. I believe it is not too much to ask, but I believe that processes and all players in those processes must be accorded to dignity and respect that they do deserve. That's all. Of that, I see a list circulating. I just want the chair to confirm that it is not a list to receive sitting allowance. So, it does not explain.
How has it reached you?
Yes.
How has it reached you?
I don't know. It was first over to me doing rounds.
That is just to indicate attendance. We just checking the attendance.
They are also expected to write. They are also expected.
I was smiling with my client here and telling him maybe to have well.
Okay, it can be pushed to the the staff of the.
Ignore, just ignore.
Oh,
it. Yeah, just ignore it. Hold the phone.
Thank you, Mr. Chair.
Yes.
Ignore it.
I wish through the chair, when counsel for the respondents were talking, we were consulting as a committee. Let us have one session. Adam Kultu, let us have one session. We were consulting. Council Konyi, Reri, and Council Shifoka. When an issue arose yesterday from the respondent's side, council side, you would see, touching on the committee, you would see the committee making inquiries to fact find. We as an arbiter, we may not be in the know over what you presented before us. We retreated and we were writing our ruling. It is good enough that you made an application before us. Otherwise, we wouldn't have known. It's good enough on your behalf and on behalf of your clients. You made an application before us. And you have asked the committee to make some orders as against the petitioner in respect of what you've applied. As earlier on communicated, after the delivery of the ruling, all other subsequent engagements, we shall handle them on Monday. You've alluded to the video clips, to communication by the petitioner. We wish to direct as a committee through the powers donated by the chair, so that we also acquaint ourselves with whatever you've informed our committee. We wish to direct that from today up to Monday morning, please kindly supply us with the clips, whether audio or video. Supply us with any materials that you have told us. Then on Monday, the committee shall take a little bit time, retreat, and analyze. Then we shall come up with our directions and decision in respect to the material you would have presented before us. The committee shall come up, if at all the committee shall be satisfied with whatever you have presented to us, we shall make orders accordingly. We do not want to preempt which orders we may give, but the orders will be based on the materials that you would have presented before us. And then we shall make our orders as the committee. I come from the legal side, and I want to inform, and that's what I've been telling members of the committee, that an advocate only works on image and reputation. And when it is tainted, you'll never get a client. And you represent men and women of repute. We must guard against reputation. We must guard against our image. We shall make our orders on Monday when you present those documents, or rather materials before the committee.
With your kind indulgence, Honorable Alunya, through the chair. We are guided and properly so. We will be doing so, we'll comply. We will share
those that are not there in public domain, which incidentally have not found its way to you as committee. Let me also say that this committee is clothed with the authority to give gagging orders now and here, because I don't want us to live here and the petitioner still goes out there doing what is done best, waiting for the committee to pronounce itself on Monday. We cannot suspend justice and fairness to our clients until such a time when it's convenient. So we are praying that this committee gives gagging orders now to the petitioner, and it's good he has counsel to interpret that to him in the vernacular that he understands. Consequently, we hope that once you grant that request to our players, I also wish to inform the commission that on Monday, quorum from our end would be Council Shifuoka Ligin, Council Mkonyi, and there will be new council from our end, because I'll be flying out on Saturday evening to India for another 10 days. That puts me away from this committee, but I hope we will convene at some other time over different issues once this has been worked out. So I think.
Council Mereri, we hope you are flying to India for the betterness of your family, of the community, and of the country.
Yes, my
we
colleague,
hope- we
I'm
hope
going
it is
to
not-
attend an international conference on tax lawyer.
Thank you so much. Thank you so much. Now, it is true that, rather as we have noted, we shall give our orders on Monday after we look at the materials you have presented before us. And we appreciate that the council has come on paper for it. Council, you heard what the respondents council have said.
Yes, Honorable.
Yeah, I wouldn't wish that you respond, but maybe you can have a seat. Please advise your client accordingly relating to this particular petition that is pending before us. In whatever manner, and if he goes against the directions of this committee, shall be adding more weight to what comes to the respondents have just submitted before us. We shall await for their documentation, but from now henceforth, let him avoid talking on any matter relating to this petition, because it is pending before us, and you know the rules guiding such a issue. Please advise your client accordingly. You had wanted to say something, but I'm giving you a minute, unless I have preempted whatever you wanted to say.
We will await the proceedings of Monday. Our colleagues have raised 9, not at least 9. Same will take 5 before we deliver decision.
Thank you. For the respondents, we are not in receipt of any materials as of now as a committee, but in the event it is so as presented before us by your councils, it is regrettable, but we shall deal with it on Monday. We wish now to go straight east of the road. For the petitioner and the respondents, there was a preliminary objection that was dated 27 November 2023 on behalf of the members of the committee and the powers donated to me by the chair. I wish to take you through our short but rather detailed ruling. petitioner and the respondents. This is a ruling that has been unanimously been agreed upon by each and every member of this committee. And therefore, I deliver on my behalf and on their behalf. This decision is in relation to a preliminary objection dated 27th November 2023, whose notice has been given on behalf, rather by the legal representatives, and was canvassed before the committee on the 29th November. It raises the following questions. And those questions and points were elaborately pointed out by the respondents as from number 1 to number 8. Reasons we have been urged by the respondents to strike out and dismiss the petition in limine without considering it in substance. The starting point is to define what a preliminary objection is. In the case of Mukisa Biscuits versus West End Distributors, that is a 1969 year at 696, it was held as follows. That a preliminary objection consists of a point of law which has been pleaded or which arises out of a clear implication out of the pleadings, and which, if argued as preliminary point, may dispose of the suit. That matter, Justice Newbold, in the said suit, further stated as follows. It raises a pure point of law, which is argued on the assumption that all the facts pleaded by the other side are correct. It cannot be raised if any fact had to be ascertained or if what is sought is the exercise of judicial discretion. Having stated the meaning of a preliminary objection, as above, we now delve into the specific points of law raised by the respondent. In relation to the first point raised by the respondent, it is the view of the committee that the strict rules of the Evidence Act and the Access to Information Act do not apply to the lodging of a petition before the county assembly by members of the public on issues within the authority of the county assembly. However, the committee has noted the issue of the signing of the affidavit by the petitioner on 20th November 2023, when on the face of it, it is seen to have been filed on 17th November 2023. This is an issue that requires an explanation which can only be possible during the hearing, as the said affidavit is comprised in the bundle of documents by the petitioner as an independent document and does not in itself make the petition valid in law, as there is no legal requirement that petitions to county assembly must be accompanied by an affidavit. The committee has gone far beyond and noted that the documents in the bundle of documents are distinct and independent from the affidavit in the said bundle of documents, and as such cannot be said that the documents comprised in the bundle of documents are annexures to the affidavit therein. Therefore, the form of the said affidavit and the manner of acquisition of the documents by the petitioner is a matter that is supposed to be put under trial, and the evidence adduced over the same and cannot be determined as a point of law. In relation to the second point, the petition that the County Assembly of Kakamega is seized of is stated to be based on the provisions of the Petitions to the County Assembly's Procedures Act number 15 of 20, which is described as follows: an act of parliament to give effect to Article 37 of the Constitution on the right to petition a county assembly to provide the procedure for the exercise of that right and for connected purposes. Therefore, the petitioner before the county assembly, having invoked the correct provisions of the law, is before the correct forum, and the petition having been committed before this committee, we have a duty to hear the parties now before us, and or any person and or body as would appear before us, and or those subject to Part 5 of the County Assembly's powers and privileges. In our opinion, therefore, we shall require or rather, that shall be required to appear before us. Standing Order number 219 makes provisions for committee of petitions to a relevant committee of the County Assembly. And this is where this committee comes in. The petition before us was committed before this committee for consideration and thus assertion by the respondents in their preliminary objection that there is no constitutional, legislative, and regulatory mandate to consider the petition is not merited. At that point, we are saying that we are guided by Article 37 of the Constitution, petitions to the County Assembly's Procedures Act number 15 of 2020, and our standing orders, more specifically 219. Therefore, this petition is properly before us, constitutionally, legislatively, and regulatory. Having a look at the objections stated at ground 3 and 4 of the preliminary objection, and without being much repetitive, the committee notes that those issues have been well addressed while dealing with ground 1 of the preliminary objection, where it has been observed that the alleged irregularly obtained documents, as the respondents called them, and alleged illegally prepared and submitted affidavit should be subjected to a trial to establish the real issues, whereby the respondents shall have a right of cross-examination. It will be upon the committee, after considering the petition, to make a determination that the petition, supporting affidavit, and annexures are bad in law. As the petition currently stands, there is compliance with the form and the requirements of the applicable legal provisions at this stage of proceedings.
Lord Jesus.
In relation to ground 5 of the preliminary objection, it relates to the principle of sub judice. The concept of sub judice is one that bars a court from trying a matter that is in one way or another before another court of competent jurisdiction by way of a previously instituted suit, as long as it is between the same parties canvassing it under the same title. This, in essence, serves to do away with different courts arriving at two distinct decisions over the same or rather similar issue. The committee has noted that the petition the respondents are referring to that had been earlier on filed is between different parties, and that the same is no longer pending before the committee, as it was withdrawn in the presence of the respondent and their counsel without going to its merits. Therefore, this limb of the preliminary objection is not merited. In relation to points 6 and 7 of the preliminary objection, the committee would not wish to belabor itself on the same, having in the preceding paragraphs made observations that such points will be well canvassed during the process of evidence hearing to ascertain the real issues in question. On the last point of preliminary objection, that is point number 8, the issues in that point were the convolution of the documents that were filed and the manner of its acquisition. The committee observes as follows. It will be difficult at this stage on the basis of the preliminary objection, without any evidence being laid in that regard, to hold as suggested in ground 8 that the petition was irregularly and clandestinely processed, documents illegally fit for the petitioner by the committee, without leading evidence to that effect, and therefore, this is a factual allegation that requires proof. Therefore, in finality, and the upshot of the above analysis is that the notice of preliminary objection dated 27 November 2023 is not merited in its entirety, and the same is hereby dismissed, and we shall therefore proceed and hear the petition in substance. Orders accordingly. This ruling has been delivered today at Kakamega, the 30th day of November 2023, by myself on behalf of the chairperson of the Committee on Public Service, County Administration.
Most of them, Honorable Chair, we made requests yesterday to be supplied with a ruling the committee delivered. We are yet to be supplied with the same. We do not know when the same shall be submitted. We also make an application that will be supplied with separate copy of that ruling. We are hoping that either by the end of the day or by Monday, we shall have a copy of the same. We thank the committee for having taken its time to retire for a bit of reasoning for that ruling. We express our gratitude for your sacrifice. We respect your position on the issues that you did raise. As much as we do not agree with them, maybe the issues become at a different level. And we particularly note that our submissions and most of the petitioners that have been jumbled up, and most of the things materially placed before you have been unaddressed. The laws we referred you to, nobody has touched on them. But nevertheless, we continue. We shall appear before you on Monday, the purpose of our continuing hearing. For record purposes, on Monday, we shall have Wakili Alvin Mkwenye. We shall have Wakili Glenn Odino, myself, and I shall also come along with my people. I hope that we will.
Thank you, Council Chipoka. Council Glenn will be presenting
All the rest.
yes, let's say
We-
Council Glenn.
yes.
Do not know whether for the petition.
I'm not speaking
Again,
for
we
the petitioner.
introduce
The petitioner has his mouth and not us. So when I speak for the respondent. So for clarity, the three councils that I've mentioned, including the people, will be on the public record.
So, we are directed before we can address the issue of supply of the ruling. Finally, counsel for the petitioner, we are just reminding that we can also supply the ruling and please once again advise your client. Because we are finishing, we are out of time. Council Chifoka, on behalf of yourself and the colleagues and the respondents also, we have a tight ruling that we have just delivered. We shall, after the session we are going to have, in terms of mourning our colleague, we shall proofread, and then after proofreading, I know by close of business, tomorrow is Friday, we shall be in receipt of these rulings. Most between your side and the side of the petitioner. I wish to hand over to the chair to conclude.
I want to believe that includes the ruling of yesterday.
Yes.
It was that.
Thank you very much, members who have attended today's hearing and ruling. On behalf of the committee, I'm very much sorry for what happened yesterday. It did not actually catch our eye, but we will actually make references and rulings on Monday after receiving your evidence. As we conclude, I think we have actually had a very good session, and I'll just ask my people to propose a second for us to close the day. Please, seconder. Seconder? I second. Good. The session starts.
Haijakuwa hivyo.
Sasa wewe utatafuta
The final one now, because now you have had
kama na ameingia sana. Sasa hivi. Ndio anashuka kwa gari. Basi. Mimi